If you have any questions, please note them down and we will take them up during the question answer session at the end. Now, let us talk about the VIDHIGYATA platform. VIDHIGYATA is a legal, educational, and professional development platform committed to bridging the gap between legal theory and practical skills through courses, workshops, publications, and mentorship initiatives. The Civil Drafting course has been specially designed to provide participants with practical exposure to drafting skills that are essential for litigation and legal practice. It is now my privilege to introduce our esteemed resource person for today's session, Dr. Mudra Singh Ma'am. Dr. Mudra Singh Ma'am is an accomplished legal admission and currently serves as an assistant professor at Amity University Lucknow Campus. She holds a PhD in law on the topic Rights of Children in India with special references to unborn persons and has completed her BA LLB honors and LLM from the University of Lucknow. With over 17 years of teaching experience and 4 years of advocacy experience before the Honorable High Court, Lucknow Bench, she brings a unique blend of academic excellence and practical legal insight. Her areas of expertise include constitutional law, criminal law, human rights, and child rights. She has presented research papers at numerous national and international conferences and has published extensively on constitutional law, criminal law, and child rights issues. Dr. Mudra Singh Ma'am has also actively contributed to child welfare and women empowerment initiatives and has been honored with the Mission Shakti Gaurav Samman for her remarkable contribution. Ma'am, we are truly honored to have you with us today and we sincerely thank you for sparing your valuable time to guide our participants. Without taking much of your time, I respectfully invite you to deliver today's session on basic principles of civil drafting. Over to you, ma'am.
Thank you, Soumya. Thank you so much for such a nice introduction. And I request you to please allow me to be a presenter. Can I use my PPT? Okay. A very good evening to the team of VIDHIGYATA and my dear students and all the participants joining the session today. I feel it's my pleasure to be invited as the chief guest for this inaugural session and first lecture of the upcoming civil drafting course, which is organized by VIDHIGYATA and the founding chief. My topic for today would be basic principles of civil drafting. Uh, Now I would like to, can you please help me? From where can I share my PPT? Okay. I shall go on the share point. the top, right? Soumya, can you help me?
Yes, ma'am.
On the top, I can see that there is a share link. So on the share, I should go and the first point that is content only. Shall I click on that?
Yes, ma'am.
Is it visible?
No, ma'am, it's not.
Okay, okay. Okay. Now it's okay.
Yes, ma'am.
Okay, fine.
Yes,
Thank
ma'am.
you. Okay, so good evening, everyone. Now, as you can see my slide here, the session today it is really very vibrant, and I suppose that it is very neat for the law students. Uh, can I know that what which semester are these? The audience of which semester?
I am from fifth semester. I'm fifth
Okay,
semester.
okay, fine. Very good, very good. So, all the
Semester, ma'am.
students who have joined here, you all are budding lawyers. Welcome you all for the session. And I think this is one of the very important initiative which has been taken by VIDHIGYATA team, because for a lawyer and especially a budding lawyer, it is very important to learn the drafting skills. And when we are talking about the drafting, because pleading and drafting both are the important aspects for a lawyer to do best in this law fraternity. So I'm going to take the session today for you. I have made this PPT keeping in mind the audience, the age group, and the students of law which have joined the session, and how this is important for them to learn as well. Because you all are going to start with this session, that is the basic course on civil drafting, and so today I will be taking a very basic principles which are very necessary. So I start now here. As you can see, the civil drafting course, which is organized by VIDHIGYATA, basic principles of civil drafting. First of all, I- what is drafting? So, can anybody tell me what do you understand by drafting? Anyone can answer? How much do you understand by drafting till now?
Ma'am, in
As
the
you all
layman
Making of
language,
legal document.
okay. So I start from here. As you know that in the law courses, whether it is LLB 3 year or LLB 5 years courses, after you study CPC and criminal procedure, that is now it is BNS.
Ma'am, you are muted.
Ma'am, you are not audible.
Voice is gone.
ma'am, somehow your
Can
mic
you
is
once
being
again
off.
say it? Unmute yourself.
Is it okay?
Yes, ma'am.
Again, you are muted, ma'am.
Again, there is a similar issue.
Similar. Your mic is muted, ma'am. Okay.
Am I audible?
Yes, ma'am.
Okay, now you can
Yes,
see
ma'am.
the slide. First of all, we'll understand what is drafting. So, in general, as you told me that about in drafting, one of you answered very correctly. So, when we talk about drafting in general, it means putting one's own ideas in writing. You frame out something in your mind and then you start writing upon it. It may be any agenda or something like. But when we talk about drafting in the in a legal fraternity, when we talk about as an advocate or somebody approaches you to write an application for somewhere where it is desired. Am I audible?
Yes, ma'am.
Yes,
Okay.
ma'am, you
Yes.
are.
Yes. Mhm.
So, drafting of any matter, it is an art, basically. And drafting of legal matters requires special greater skills and efficiencies. Now, when we talk about drafting in the law field, as you all know that after completing your law courses, you will be approaching and now for the different summer internships will be going for to learn the pleading and drafting part, how to draft an application, how to draft uh, a plaint, and sometimes it is required to draft a complaint when the FIR is not lodged, or so many different other aspects. So when we talk about in legal matters, it needs specific skills, and for certain skills, you have to be very updated. I think there is some problem with my voice. It is creating an echo. Can anybody
Yes, ma'am,
please
there is.
please
Yes,
all of
ma'am,
you
there
mute?
is.
बच्चे आप लोग म्यूट कर लोगे तो शायद सही हो जाएगा. किसी का शायद माइक खुला है. So drafting in the law field requires a special knowledge in the field of law as well as
Again, your
Again,
mic
your
is
mic
muted,
is
ma'am.
muted.
There is issue with your mic.
Ma'am, you are muted. Still,
No, ma'am.
ma'am is still mute.
Ma'am, your mic is muted. We
Your
are
mic is
unable to
muted,
hear
ma'am.
you.
बेटा कोई म्यूट कर रहा है बार बार. आप देखो इस पे, है ना?
Is there any possibility someone is doing this from the candidates?
Yes.
I think.
हाँ, कोई कर रहा है मैम. सबका माइक
Ma'am,
म्यूट कर
there
रहा है
is
कोई.
Yes,
someone
ma'am.
is
Yes, there is a possibility to mute.
आपका फिर से म्यूट कर दिया कोई.
बेटा कोई म्यूट कर रहा है, मैं नहीं कर रही हूँ. आप लोग चेक कर लो अपने एंड पे.
सबके माइक को कोई म्यूट कर रहा है. कोई एक है.
हाँ, ऐसा करो आप लोग ये
Ma'am,
पावर यू नो दैट
Ma'am,
हाउ टू
actually,
I'm host वो कर सकता है
I'm the team
actually
member
कि
of
वो
VIDHIGYATA.
Ma'am, there is a miscellaneous person who is doing such act.
हाँ, जो
हाँ देखिए
होस्ट है
फिर
मैम
बार
वो
बार
कर
म्यूट
सकता
कर
है.
रहा है.
सबके माइक
Yes,
को म्यूट कर
ma'am.
रहा है.
आप राइट्स ले लो. इफ यू कुड कंट्रोल, इवन आई आल्सो यूज्ड टू use this MS Team. Somebody is doing that, so please take the charge. Okay, thank you. I'm back again. So yes, back to the topic. It requires special knowledge in the field of law. Now, before proceeding ahead, the basic things which I must share to you, because you all are the students of law, and in the beginning semesters, how it is important for you the drafting and as well as the pleading. So before, as the your topic has been suggested that it is civil drafting. So when we talk about drafting, it is always incomplete without pleading. So if you have studied in CPC, I suppose many of you would have completed your CPC, Civil Procedure Code.
Yes, ma'am, completed.
Okay. So in
No, ma'am.
CPC, you...
No, ma'am.
Oh,
No, ma'am.
oh, okay, fine. So I'll be dealing with that accordingly as per your requirements. So when we talk about drafting, first thing you should keep in your mind that drafting always is included with pleading. So, if you have to become an effective and efficient and a good lawyer, you have to have command on both the things equally, as on the pleading as well as on the drafting. Now, before proceeding for the drafting, the basic thing which you should keep in your mind that as a lawyer, when you approach to a client approaches to your problem in society, any kind of, it may be child labor, it can be any FOXO related matter, or it can be a rape case, it can be a domestic violence, matrimonial issues, whatever it be. So first thing you will be asking about the basic facts of the case. So when you know the facts of the case, you are able to decide that what is the nature of the case. If let's suppose it is a civil case where some specific contract has been there, and you have to make that contract uh, complete, or if there is a part performance of the contract has been made and the rest of the portion has not been completed, so accordingly, the nature of the case, after going through the facts, you will be able to clarify that what kind of drafting is required in this, right? Am I audible?
Yes,
Crystal clear,
Yes,
ma'am.
ma'am.
ma'am. Yes,
Yes,
ma'am.
ma'am.
Yes, ma'am.
Okay. So as you have chosen a very important topic, and I suppose as a lawyer and as well as even if you go in further in your academia field, or if you become a judge, drafting is very important along with the pleading. So first thing that pleading includes both the things, drafting as well as pleading before the judge. As a lawyer, whether it is the plaintiff or the defendant side, or it is a prosecution or the defense side, both of the parties have to draft their applications, draft their a memorandum, draft their memorials, like you would have been participating in your moot court competitions. So you go to the facts thoroughly and then you start drafting accordingly. So basic things which you should keep in mind, that you should have a good knowledge of the facts. आपको अच्छे से fact sheet अपनी पढ़नी आनी चाहिए. अगर आप लॉयर अच्छे लॉयर बनना चाहते हैं तो सबसे पहले तो बहुत ही इंपॉर्टेंट है कि जो भी आपका क्लाइंट है उसको ध्यान से सुने, उसकी बातों को ध्यान से नोट करें, एंड यू हैव अ थॉरो लिसनिंग, एंड आफ्टर दैट यू मेक इंपॉर्टेंट headlines include the facts. Now application of the law upon that facts will clarify that what kind of draft is going to be prepared here, and what all applications, what all procedure will be applied, and what all the judicial principles beside the efficient English. If it is an English drafting, fine. As you all know, then the high courts and the Supreme Courts, it is on English, always English language. But if you go to the lower courts, the children, you all have to be very thorough with the Hindi language as well. तो वहां पर आपको हिंदी भी अच्छी पकड़ होनी चाहिए, और जुडिशरी के जो स्टूडेंट्स प्रिपेयर कर रहे हैं उनको इंग्लिश और हिंदी दोनों पे बराबर कमांड होना चाहिए. नेक्स्ट पॉइंट है a perfect drafting of matters in relation to suits, applications, complaints, writ petitions, whether it is appeal or revision or review, whatever matters which are connected, they must obviously lead to a good result. Because ultimately, being a lawyer, you have to earn a good money, or you have to showcase your case in the best of the best way before the judge, so that in the first hearing only you win your case accordingly. So it's very important that how you're going to portray your case, how you're going to present your case in a well-mannered way. So the first thing is important, that application of those law based upon and applying those law in the facts. Suppose there was an application where there were two possibilities. There was a tort case also. आपने बहुत ही फेमस केसेस पढ़े होंगे अभी तक अपनी बुक्स में. तो जहां पर आपको दो जगह एप्लीकेशन मिलता है, आप उसको टॉर्ट में भी फाइल कर सकते हो, आप उसको सीपीसी में भी फाइल कर सकते हो, टेम्परेरी इंजंक्शन के लिए भी ले सकते हो. कभी कभी वो चीज आपको सिंपल ट्रेसपास में जाती है, और कभी कभी वो क्रिमिनल ट्रेसपास में चला जाता है. तो ये आप पर निर्भर करता है हाउ यू गोइंग टू मेक इट द डिपेंडिंग अपॉन द फैक्ट्स ऑफ द केस. सो इट इज वेरी इंपॉर्टेंट. Next, it creates a congenial atmosphere where the glory of the judiciary and the law grows to sky heights. If you have a good command on your drafting skills, one of my student in the first in 2011, when he completed his BLLB honors, he was earning on the basis of drafting only, because he was very well versed in drafting skills. उसको कोई भी सिविल प्लेंट आप दे दो, वो फटाफट ड्राफ्ट करके 2 दिन में वो दे देता था. तो he was earning good money on that basis. So you should have a good command on that. और उसके लिए दो चीजें बहुत इंपॉर्टेंट है. पहला तो फैक्ट्स को अच्छे से पढ़ना, उसके बाद उस फैक्ट पर जो भी अभी आपने अभी तक की नॉलेज गेन करी है, जो भी आपने लॉज सब्सटेंटिव लॉज पढ़े हैं, दैट इज सपोज इट वाज आईपीसी, नाउ इट इज बीएनएस. You have to have good command on CPC. You have to have good command on the other, that is, for example, Limitation Act, whether that case is within the limitation period or not. You should be thorough with that. And then you have to apply with that procedure everything, substantive as well as procedure law. So both the things are very important. Now, before moving ahead, I would like to again explain you that first, after going through the facts, you are clear that it is a civil nature case, or it is a civil suit. So there you have to be very clearly, specifically know that what kind of procedures in the civil law has to be applied, and it is not a criminal case. तो अभी चूंकि हमारा आज का टॉपिक सिविल ड्राफ्टिंग पे, तो हम लोग सिविल ड्राफ्टिंग पर फोकस करेंगे. जब आपको पहले प्राइमा फेसी केस में ये लगता है कि ये क्रिमिनल साइडेड इंक्लाइन केस है, क्योंकि कई बार ऐसा होता है फैक्ट शीट पढ़ने के बाद आपको लगता है ये तो क्रिमिनल केस बन रहा है, इस पर आप क्रिमिनल कंप्लेंट फाइल कर सकते हो या एफआईआर के लिए, तो आपका केस तुरंत चेंज हो जाता है. तो अभी हम सिविल ड्राफ्टिंग की बात करते हैं. और दूसरा इंपॉर्टेंट फैक्टर ये कि व्हेन यू आर ड्राफ्टिंग, you have to keep in mind that it has to be very precise, it has to have in terms of law, so that at a prima facie case the judge appreciates your drafting, and in the prima facie you get your remedy, because at the end you have to present your prayer before the court. Now drafting and pleading, why it is an essential tool for litigation. As you know, the importance of drafting and pleading in the current society is that now various platforms are there now. Nowadays, online consultation is also there. So many firms are working. Even advocates, they have a team of drafting person that only they only draft the applications. They only draft the civil suit. If you talk about the civil drafting, there are a lot
Excuse me,
of
ma'am.
needs. Yes.
Sorry for interrupting. Ma'am, I have a question over here. While
Yes.
I was doing an internship in the district court,
Mm,
sometimes the client get emotional,
yes.
and they are not the things that we have to mention or how we should express them in drafting. Their emotions, sometimes they are admitting some guilt and something like that. How could we draft these things on the draft on the document?
You want to ask that how you have to settle those emotions into the drafting, right?
Sometimes some client get more emotional on that situation.
Yes. It's a very good question. Actually, it happens in especially in the matrimonial disputes. Basically, I think if I could explain you with an example of a matrimonial case. There was a case in which the both the parties proceeded for a divorce petition based upon the cruelty ground, right? So, meanwhile, in the starting, they had a very chaos and they started with the litigation and everything, even beyond that of mediation and conciliation. But by the time after 2 to 3 years, as you are saying that they got very emotional and they started meeting each other. Now the question arises on the other side. एक तरफ तो आप इमोशनल हो गए, दूसरी तरफ आप कोर्ट की प्रोसीडिंग चल रही है. तो लॉयर पर्सपेक्टिव से, एक एडवोकेट की पर्सपेक्टिव से, you have to be very clear on this point कि what your client wants. तो यू हैव टू आस्क योर क्लाइंट. अगर आपका क्लाइंट क्लियरली, क्योंकि आपको ये बात फैक्ट्स पढ़ते समय समझते समय अपने क्लाइंट से साफ पूछ लेनी चाहिए कि आप क्या चाहते हो. और अगर आपका क्लाइंट ये क्लियरली कहता है कि मुझे डाइवोर्स चाहिए, या कल को 2 साल बाद उसको ये लगता है कि नहीं हम रिकंसिलिएट कर सकते हैं या हम कॉम्प्रोमाइज कर, जैसे अभी एक रेप का केस आया था. एक रेप के केस में क्या हुआ, स्टार्टिंग में उन्होंने फाइल किया, बाद में उनके बीच में मेमोरेंडम साइन हो गया और उन्होंने कुछ आई थिंक सपोज 11 लाख रुपीज समथिंग लेकर के दे आर नाउ टू सेटलिंग दिस केस. तो ये जो आपने बात कही इमोशंस आते हैं, तो पहली बात तो मैं क्लियर कर दूं कि ड्राफ्टिंग में कभी भी इमोशंस को नहीं लाना चाहिए. अगर आपके इमोशंस हैं भी तो उनको बहुत ही, एक एडवोकेट को बहुत ही स्मार्टली डील करना चाहिए. आपको लग भी रहा है तो उसको एक तरीका होता है पुट अप करने का. सपोज आपको मेंटेनेंस चाहिए, है ना? तो आप, आपके इमोशंस पॉजिटिव है या नेगेटिव है? जैसे जिस केस की मैं बात कर रही हूँ उसमें उनको डॉटर, ही वाज वेरी इमोशनल क्योंकि उनको अपनी डॉटर की कस्टडी चाहिए थी. तो ही स्टार्टेड द केस इन दैट वे. तो हमें उस अकॉर्डिंगली ड्राफ्ट करना पड़ा या हमको उस अकॉर्डिंगली उनको गाइड करना पड़ा. तो इमोशंस आपके टकराएंगे, लेकिन लॉ कभी भी इमोशंस में नहीं बह के किया जा सकता है. लॉ की बेस जो ड्राफ्टिंग होती है वो हमेशा नॉलेज ऑफ लॉ पर बेस्ड होती है. और ऐसे बहुत सारे मैक्सिम्स अभी आप लोग पढ़ोगे जिसमें कि यहाँ तक की है कि भाई अगर आपने कभी आपको लग रहा है कि भाई इस जगह पे इमोशनल हो गया, आपको कॉम्प्रोमाइज करना, तो वो आपको क्लियर करना पड़ेगा कि आप चाहते क्या हो रेमेडी में. क्योंकि एक केस में आपके पास दो तरीके हैं. आप एक तरफ कॉम्पनसेशन क्लेम कर सकते हो, और अगर आपका इमोशंस कहता है नहीं नहीं मुझे तो इसको सजा दिलानी है, तो अगर आपको सजा दिलानी है तो वो आपकी वो दूसरे एंगल पे केस बनेगा. तो ये आपने बहुत अच्छा क्वेश्चन पूछा, और ये चीज आपको अपने क्लाइंट से क्लियर कर लेनी चाहिए बहुत ही स्टार्टिंग में कि वो क्या चाहता है. और थोड़े समय बाद एक एक्सपीरियंस भी बताता है कि भाई ऐसे केसेस में क्या होने की संभावना बनती है आगे जाकर. और जनरली कई केसेस में आगे जाकर के रिकंसिलिएट हो जाता है, कॉम्प्रोमाइज हो जाता है, लेकिन सभी केसेस में ऐसा नहीं होता है.
Yes, ma'am.
तो ठीक है, तो ये केस टू केस वेरी करता है. अभी मैं आपको बहुत सारे एग्जांपल जैसे दे भी सकती हूँ कि बिकॉज व्हेन आई वाज प्रैक्टिसिंग आई गॉट टू नो इवन करेंटली यू कैन फाइंड सो मेनी केसेस आर देयर कि भाई स्टार्टिंग में तो बहुत एग्रेशन में उन्होंने केस फाइल कर दिया और बाद में वो दो भाई लड़ते लड़ते इमोशनल हो गए और कहीं पर कंसीलिएट भी कर लिया. और कुछ ऐसे भी केसेस है जहाँ पर जमीनी विवाद था, शुरुआत तो सिविल सूट से हुआ था हस्बैंड वाइफ का और या फिर भाई भाई का, और बाद में उन्होंने क्या हुआ कि वो क्रिमिनल केस में कन्वर्ट हो गया. तो इमोशंस का खेल ऐसा ही है. तो बट एज एन एडवोकेट आपको हमेशा अपने क्लाइंट को सही दिशा देनी है, उसको सही गाइड करना है, और वो क्या चाहता है ये आपको क्लियर होना जरूरी है. क्योंकि यही आपका डिसाइड करेगा कि आप कोर्ट में प्रेयर क्या करने जा रहे हो. पता लगा आपका क्लाइंट कुछ और चाह रहा है और आपने प्रेयर कुछ और कर दी जज के सामने, तो
Right, ma'am.
वो ठीक है. तो ये ध्यान रखना होगा हमेशा. Now, shall I proceed?
Ma'am,
Please, ma'am.
ma'am, before proceeding,
ma'am.
I want to remind every contestant that they have to save their question for the end of the session. Time will be provided for them to ask questions. Please do not interrupt in between.
Okay, students, I welcome all your questions. I'll certainly answer your questions after the session. I'll try to complete my presentation within the time. So now moving ahead, that before we proceed, we must understand why drafting and pleading is an essential tool for litigation. आप सभी को मालूम है जितनी अच्छी आपको ड्राफ्टिंग उतनी ही अच्छी आपकी प्लीडिंग होनी चाहिए। अगर इसे कहा जाए कि एक एडवोकेट की जो कहते हैं ना अधिवक्ता एंड वक्ता, इनमें ही दोनों चीजें छुपी हुई है। तो जितना अच्छा आपका क्लियरली थॉट्स होगा, क्लियर थॉट्स होगा। I hope you are comfortable in the both the communication. I can just carry on with in English only. I have no problem with that.
Ma'am, we are comfortable with the English. More of it.
Okay. Okay. So when we talk
Yes,
about
ma'am.
drafting and pleading, both are essential tools because for litigation, an advocate or the lawyer, it is very essential that he must have a good command on drafting. But before you start with your drafting, you have to be very thorough with that, what the content, what the facts of the case are, and then crystallizing those facts and expression of that, what legal right or privileges, functions, duties, as well as status are there. So if we say there is no such clear-cut definition for drafting, but it is very important, it is very essential for litigation that first thing you have to understand from the side of the client that what he desires, what he is wanting, where his legal right is violated, number one. Secondly, what are the other privileges? So you have to take the case, both the sides, what are the pros and cons of the case, even what are his duties. For example, I say if there is a divorce petition, so what is the duty of a husband, what is the duty of the wife, and what the law says, Hindu Marriage Act, or it be in any other case. If there is a specific performance of contract, what are the duties and liabilities and privileges of both the parties? Or if it is a sale deed, what is the duty of the both the parties? So it will decide the legal right and where it is a violation and where is the cause of action created, and then what is the remedy, legal remedy which is provided for which you should proceed before the court. So these things you should be very clear. Before you start with your drafting, you have to have a lot of study, you have to go through a lot of case studies, recent landmark judgments, and current what is going on. So not necessarily that before 10 years, what was the case and whether it is implicated on the other courts or not, that those things you have to be very updated. Next, we talk about the civil drafting. Now we're focusing upon the civil drafting. So this includes a lot of things when we talk about civil drafting. Firstly, drafting of a deed. Indeed, when we talk about CPC, we'll be studying further. A lot of instruments are there. For example, sale deed, mortgage deed, and other lease deed, even gift deed, or any other kind of a document. So from basic beginners, students who are in the first semester and the second and third semester, they should know what is wakalatnama, how to draft affidavit, and how to draft a plaint. So before you start with the drafting, you have to work out on these things. Next is embodiment as an agreement between the parties. So what is the fact, and then what are the agreement between the two parties? What has been decided earlier? Is it on paper? Is it on records? What are the documentary proof for that? And what are the intentions? Whether the part has been, the duties have been performed by the parties, whether is there any lacuna. So if there is any kind of
Ma'am, please explain in Hindi also.
okay, fine. I'll explain Hindi also. So आपको ये एक एडवोकेट की तरफ से
Hello,
दोनों
ma'am.
तरफ,
Excuse me.
yes.
Ma'am, we are students from South, so English is better.
Okay, I'll try to yes.
I think, ma'am, you should explain in Hindi and English, both English.
Shall I
अगर आप
continue?
हिंदी में बताएंगे तो दोनों के लिए हेल्पफुल रहेगा।
Okay, मैं कोशिश
दोनों
करती हूँ. That is why I was asking कि
Okay.
whether both of you, both the languages are comfortable, so I'll try to make that possible. So जब आप प्रोसीड करते हैं तो आपको ये चीजें ध्यान देनी पड़ेंगी कि क्या क्या उनके ड्यूटीज थे और क्या क्या उनके राइट्स थे, क्या क्या उनके प्रिविलेजेस थे, कहाँ तक उन्होंने ड्यूटीज परफॉर्म की है, क्या क्या डॉक्यूमेंट. फॉर एग्जाम्पल एक छोटा सा केस बात करते हैं. LIC LIC में एक standard contract है. There is a standard form of contract. You have made LIC policy, and suppose it's a term insurance. After X person has made an LIC, has paid for 15 years, वो 15 साल के लिए जमा करता है. उसके बाद उसकी डेथ हो जाती है और टर्म इंश्योरेंस के मुताबिक उसकी फैमिली को जो भी नॉमिनी है उसको 1.5 करोड़ रुपए मिलना चाहिए. The nominee should get 1.5 crores after he is made any kind of exigency. So in that case, what the standard draft, whether those things are on paper, on record, whether had that contract been signed and formulated in the deed, in the written form or not, the parties have signed, all the documentation. Nowadays, it is since one development has been made that, as you know, that recently that it has been an amendment in the Bharatiya Sakshya Adhiniyam as well, that electronic evidences are also admissible now. So that is important when you are drafting. In reference to, there are so many things nowadays when you're drafting, whether WhatsApp chat, what other electronic devices, records are there available for us or not. अभी आप बहुत सारी चीजों को ओके करते चले जाते हो. पॉसिबली आपने देखा होगा कि जब कभी आप मोबाइल चलाते हो तो उसमें आपने देखा होगा बहुत सारे एग्रीमेंट्स आप ऐसे ही कर देते हो. तो हम लोग कई बार उनको पढ़ते नहीं. तो ये हर चीज यहाँ पर बहुत ही इंपॉर्टेंट है. इसके पर्सपेक्टिव में जब हम सिविल ड्राफ्टिंग की बात करते हैं तो now I move ahead. What is the importance of drafting in litigation? As you know that, first of all, the first and the most important thing is that meeting the client's goal and carry out the client's instructions. First thing, you listen to your client very carefully. अपने client को बहुत ध्यान से सुनना. वो क्या चाहता है, उसकी क्या requirements है, उसको क्या क्या उसकी legal rights कहाँ कहाँ पर उसके violate हुए हैं, उसकी कौन सी उसको क्या रेमेडी चाहिए, what remedy he is requesting you, what he actually desires. Suppose there is an example of you met with the X person met with an accident. Now one option is that he wants to claim a compensation provided he is all the documentation complete. एक तो ये है कि वो compensation claim कर ले. दूसरा ये है कि वो criminal suit file कर सकता है. तो दोनों चीजें. तो ये आपको क्लाइंट से पहले क्लैरिफाई करना है. क्लाइंटेज समझना बहुत इंपॉर्टेंट. इसके बाद नेक्स्ट आप आते हैं. It helps in maintaining the standard of care which protects the interest of the client. So but obvious है, जब आप अपने client को ध्यान से सुनते हैं तो आपको ये समझ आ जाता है, आपको clear हो जाता है कि how you are going to protect the interest of your client. And in that direction, you have to draft your plaint in that very specific mannerism. Next, it helps accurately addressing all the relevant legal factual issues. Now, this is very important. You have to ignore so many other things. You have to have only focus on the relevant legal issues. लाइक फॉर एग्जाम्पल, जब आप अपनी क्लाइंट से बात करते हैं, क्लाइंट आपको बहुत सारी चीजें बताता है. इवन जब आप कोर्ट में एड्रेस करते हो, व्हेन यू प्लीड बिफोर द कोर्ट, यू आल्सो पुट अप योर फैक्ट्स एंड इश्यूज वन बाय वन. बट फॉर एड्रेसिंग दोज इश्यूज, you have to explain so many other examples. Like right now, I'm explaining you so many things, quoting a lot of examples just randomly because as coming in my mind. So to make you understand that those things. So it is very necessary that what relevant is there, you should be very focused upon that based upon the fact sheet which is produced before you by your client. अब ऐसा ना हो कि आपने क्लाइंट ने आपसे रेमेडी कुछ और मांगी है और आपने ड्राफ्टिंग में कुछ और लिख दिया है. अब मैं एक आपको छोटा सा केस बता रही हूँ. एक जगह पर देयर वाज सम इंसिडेंट वेयर इट वाज द केस ऑफ डाइवोर्स. But by the time the husband was not clear ki which kind, whether the cruelty and which of the grounds of divorce should be put up. So he was not clear. इसने बताया लेटर ऑन कुछ और अपने एडवोकेट को, और एडवोकेट ने ड्राफ्टिंग करते वक्त उसने कुछ और लिख दिया. अब जब कोर्ट में प्लीडिंग के टाइम पे आए तो मैंने आपको बताया ना, दो बहुत ही इंपॉर्टेंट चीजें. वन इज ड्राफ्टिंग, जो आप राइटिंग में अपने उस कंटेंट को तैयार करके कोर्ट के सामने प्रोड्यूस करते हो, पेश करते हो, और जो उसी के बेसिस पे आप प्लीड करते हो कोर्ट के सामने. तो वट एवर यू आर प्लीडिंग बिफोर द कोर्ट, it is actually based upon your drafting. Now, if you have written something else, mostly what happens in the moot court competition, sometimes students you would have seen that वो लिख कुछ और रहे होते हैं और प्रेजेंट कुछ और रहे होते हैं. तो एटलीस्ट देयर शुड बी वेरी क्लैरिटी इन योर थॉट दैट व्हाट यू आर ड्राफ्टिंग, and it should be based upon essential part, based upon the facts given by your client. Next is precedence form and essential part in drafting, because if suppose you are drafting and you are asking for a remedy of a specific issue, so you have to quote the landmark judgments in addressing your issue, so that you have the maximum chances, maximum probability of winning of your case in your favor. So the precedents have a very important role while drafting of the case. एक केस को आपको पढ़ने के लिए कम से कम 100 से ज्यादा केसेस आपको कोट करने पड़ते हैं, पढ़ने पड़ते हैं। कई अगर मैं आपको एग्जांपल बताऊं, राम जन्मभूमि आंदोलन आपने पढ़ा होगा, 1000 पेजेस से भी ज्यादा उसका जजमेंट है। तो यू वुड हैव सीन लॉट ऑफ जजमेंट्स हैव बीन कोटेड। केशवानंद भारती का केस देख लीजिए, पुट्टा स्वामी का केस देखिए, देयर लॉट ऑफ लैंडमार्क केसेस वेयर लैंडमार्क केसेस हैव बीन कोटेड एंड they are always quoted. Right to privacy की बात करेंगे, always will find that some Maneka Gandhi case and the right of Putta Swami case. So likewise, you have to make a series of cases in supporting your arguments. Next is prerequisites of legal drafting. Before you start with your drafting, the first important thing that a proper understanding of drafting cannot be realized unless the nexus between the law, facts, and the language. As I told you, first you should be very clear the facts of the case. Now, the facts once you have studied, you are thorough with your law, whether it is substantive or it is procedural, and also the language. अगर आप डिस्ट्रिक्ट कोर्ट में फाइल कर रहे हैं तो आपको समझना पड़ेगा कि डिस्ट्रिक्ट कोर्ट में क्या लैंग्वेज आपको यूज करनी है। फाइलिंग इन हाई कोर्ट और सुप्रीम कोर्ट, यू हैव टू वेरी क्लियरली स्पेसिफाई दैट व्हाट actually the language you have to prefer. And as a lawyer, I suggest you should have a good command on both English as well as Hindi, because ultimately if you're proceeding or planning or you have a target for approaching the Honorable Supreme Court of India, you have to have a good command in the English language and high courts as well. And for district courts, basically it is the local languages which is used. So the facts, secondly the law which is to be applicable upon that fact, and thirdly the language. It is to be fully understood and accepted. कई बार आपने देखा होगा कि जो डिस्ट्रिक्ट कोर्ट में, तहसील में, अगर मैं एग्जांपल आपको कोट करूं तो तहसील में की अदालतों में कई बार आप देखते हो कि हिंदी लैंग्वेज ही प्रेफरेबली यूज करते हैं। और कई बार वहां के वकीलों में, और कई बार ऐसा होता है कि जिस वकील ने ड्राफ्ट किया है तो इंग्लिश में, लेकिन वो बोल नहीं पा रहा है इंग्लिश में। हिंदी में ड्राफ्टिंग करी है और इंग्लिश में नहीं बोल पा रहा है, इंग्लिश में ड्राफ्टिंग करी, हिंदी में बोल रहा है। तो ये बहुत इंपॉर्टेंट एस्पेक्ट होता है। इसी के साथ आपको ये भी ध्यान रखना पड़ेगा कि वहां पर आपके क्लाइंट ने क्या बातें आपको बताई, उसको आपने ठीक ठाक उसी तरीके से इंटरप्रिटेशन करके उसी लैंग्वेज और उसी इंटेंट के साथ वहां पर आपने उसको ड्राफ्ट किया है। अब एक केस में था डंडे से मारने में और एक लोहे की रॉड से मारने में, केस का पूरा पूरा चार्जेस ही बदल गया। आप भी बेटर समझ सकते हो, अगर किसी ने एक सिर्फ लकड़ी के छोटे डंडे से मारा है और एक व्यक्ति ने अगर रॉड से किसी को हर्ट किया है, तो देयर इज अ डिफरेंस बिटवीन द टू एंड लॉट ऑफ changes, and that will be the basis of the charge sheet as well. So that how you have to be very careful कि facts को आप कैसे उस पर law apply करते हो, the language जो आप choose करते हो. It is very important aspect on that point. Next is that draft should be very free from ambiguity and doubtful connotation. Dear students, dear participants, this is very important aspect. When you are drafting, you have to be very clear. You have to be very precise upon the facts. Let's suppose somebody's date of birth was there, and some one woman was asked about the date of birth of the son, while in some case, so she told that पूर्णिमा का चांद था। अब पूर्णिमा का चांद वो कौन से ईयर में कौन सी कितनी पूर्णिमा हुई पता नहीं, तो इट इज अ डाउटफुल सिचुएशन। वो एम्बिग्यूटी नहीं क्रिएट करनी, यू हैव टू वेरी प्रिसाइज। लाइक फॉर एग्जांपल भारतीय साक्ष्य अधिनियम में ये साफ साफ दिया हुआ है 280 days gestation period. So it has to be 280 gestation period, not near about. So near about something which is creating ambiguity should not be there. Something which is doubt creating doubt. There are a lot of cases. I think you people with this studying जहाँ पर आपकी रेट खारिज हो गई है, जहाँ पर आपको केस को प्लीडिंग नहीं आगे अलाउ किया गया कि जस्ट बिकॉज ऑफ द डाउटफुल सिचुएशन और बेनिफिट ऑफ डाउट में केस खारिज हो जाता है। तो ये ध्यान रखना पड़ेगा कि इट शुड बी फ्री फ्रॉम दोज थिंग्स। लास्ट इज नथिंग इज टू बी omitted or admitted at random. आप लास्ट मिनट कोई चेंजेस ना करें। whatever you're drafting in your plaint or WS or writ petitions, if you're drafting, if it is accordingly as per the cases, you have to be very certain and firm on it. You don't have to just omit or admit at the last moment, or if there is any requirement, there has to be amendment of pleading that later stage with the permission of the court. Now we come to the point of pleading. So as I told you, there are two major things when we talk about drafting: pleadings and drafting. So meaning of pleading are basically It is a statement in writing drawn up and filed by each party to a case, stating what his contentions will be at the trial and giving all such details as his opponent needs to know in order to prepare his case in answer. So it is also given there in CPC Order 6, Rule 1. So as you can see here, it is quoted, and pleading under Order 6 includes, it means plain or WS, that is written statement. So इसके बिना तो आपकी ड्राफ्टिंग अधूरी है, इसके बिना आपकी ड्राफ्टिंग इनकम्प्लीट है। तो सबसे पहले आपको ये समझना होगा कि व्हाट इज प्लीडिंग। सो प्लीडिंग जब हम बात करते हैं, प्लीडिंग इज बेसिकली इंक्लूडेड स्टेटमेंट in first of all in writing what both the parties, first of all because it initiates with the party who is a complainant or who is having a who is suffering from any legal any kind of violation of his or her right. So the party which is proceeding before the court, what he is trying to put up in his plaint first, that is important. And next, after the plaint is filed before the court, what the other party upon which the allegations are put up, upon whom the charges are being put, that is very important. That what the other party is trying to take the defense, that is the written statement. So these two important aspects are a major role of pleading, as it is also defined under Order 6, Rule 1, that Code of Civil Procedure 1908 provides that pleading means plaint and WS, plaint or written statement. So you have to be very clear on this point. If you are a plaintiff, you have to have very precisely talk to your client that what is where is the legal violation, what is the remedy for that, what your client wants. So accordingly, you will file your plaint and then the other party with the written statement. Every pleading shall as obviously be signed by the parties and the pleader. Next is Order 6 with Rule 15 precisely said that every pleading shall be verified at the foot by the party or by one of the parties pleading. You know, students, that when you would have seen that when a suit is filed, there is also a verification part and also followed by an affidavit. That whatever statements you have mentioned here in your pleading, that are true to your best knowledge. तो आप एक एफिडेविट भी देते हो कि जो भी आपने अपने प्लेंट में दायर किया है, मुकदमा फाइल किया है, वो सब कुछ आपकी नॉलेज में सब कुछ सच है और सही है, कुछ भी इसमें आपने छुपाया नहीं है कोर्ट से। बिकॉज यू नो दैट देयर आर सो मेनी अदर चार्जेस कि अगर आपने कोर्ट को गुमराह किया है तो वहां पर भी अलग चार्जेस फ्रेम हो सकते हैं। नाउ आफ्टर दिस प्लीडिंग, जब हम प्लीडिंग की बात करते हैं तो इसमें सबसे पहले, चूंकि प्लीडिंग इज प्लेंट और WS, so first of all we'll know what is plaint. As I told you, in CPC, since it is civil procedure, it states that under section 26 that every suit must be instituted by the presentation of a plaint, and in every plaint the facts must be provided by an affidavit. So first your plaint, and then it should be followed with an affidavit signed by two persons, that is the witnesses. Next is Order 7, Rule 1 of CPC lays down the mandatory particulars which must be stated in a plaint. Now, these points which are shared, which I have included in my PPTs, that this is very important perspective while you're drafting for a plaint. So, Order 7, Rule 1 provides a detailed prescription that these all things will be very clearly and precisely mentioned in your draft. At the end, I'll show you a draft also. I have prepared something for just to show you that if time is there, I'll share it with you. First thing is the name of the court, where whatever the jurisdiction of the court is, the description and place of residence of the plaintiff, the description and place of residence of defendant, both the parties, and then the plaintiff or defendant if it is a minor or if it is a person of unsound mind or statement to that effect. अगर कोई unsound mind का है या minor बच्चा है, आपने मोरी बेबी का केस पढ़ा होगा, so ऐसे बहुत सारे cases है जिसमें accordingly you have to present. So these are the points where you have to be very clear while civil drafting, that what are the, in which court you have filed, what is the jurisdiction of the court, name and all details of the plaintiff. If there are more than one party, so how you are going to write those. Then if it is a minor case or if it is a person of unsound mind, if any representative case, how you are going to put up those in your plaint. Next is that facts constituting the cause of action. Yes, this is very important. After you have mentioned all these things in the body, the cause of action is very important. How you have to show that how the right exists. Suppose there is a land and another person has made a illegal you can say it is, if there is a trespass on the land, so how you have to first you have to establish that how the right of the person exists on that land, and how this right has been violated, making the cause of action, how why you need to proceed before the court, what is the issue, what remedy you want to proceed for to get the from the court. So that makes the cause of action whereby you proceeding before the court, and whether it is the right court or not. So there are other laws also. When you are drafting, you have to be very clear that whether it is appeal or if it is a revision or it is a if it is a matrimonial dispute, where in which court you have to file that suit. Next, where the relief is the plaintiff claims. Yes, obviously, where the plaintiff is allowed a set off or relinquished a portion of his claim, the amount so allowed and relinquished. अगर ऐसा कोई केस है जहाँ पे आप सेट ऑफ करते हो, आप सीपीसी में पढ़ोगे आगे कि अगर आप किसी प्रॉपर्टी को किसी दूसरे प्रॉपर्टी से सेट ऑफ करते हो तो उसका क्या अमाउंट है, उसको किस तरीके से आप एडजस्ट करते हो, तो दैट इज इम्पोर्टेंट. Next is statement of value of subject matter of the suit for the purpose of jurisdiction and the court fees. Yes, students, it's very important that what is the court fees. Let's suppose आप एक 2 करोड़ की जमीन का अगर आप एक सेल डीड करने जा रहे हो, there is a proper fees of that, and the court fees act that allows that what is the specific fees for the registration of that amount of property, and that will be made accordingly. So these are some very important points which are to be very kept in mind while drafting your plaints in civil cases, and that you have to be clear. Now next, once the plaint is drafted and filed by the plaintiff, now it is the other side party, that is the defendant, the written statement which the other party has to present in his defense. वो अपनी सफाई में क्या पेश करेगा, वो अपने W written statement में plaintiff की साइड से जो उस पे चार्जेस लगाए गए हैं, जो एलिगेशंस लगाए गए हैं, जो उसको रेमेडी चाहिए, जो उसका वायलेशन हुआ है, तो WS यानी कि डिफेंस की साइड से डिफेंडेंट उनका क्या जवाब देता है. अगर आप लेट सपोज कहता है, ए कहता है ये प्रॉपर्टी तो मेरी है, ये बी ने ट्रेसपास किया, तो अब बी के पार्ट पे कि हाउ बी इज गोइंग टू टेक अ डिफेंस दैट ही हैज दिस प्रॉपर्टी डज नॉट exist to A, and how B belongs to it, and B is the owner and B has not made a trespass. B ने कोई भी ऐसा वायलेशन नहीं किया है, B को रेमेडी उसको कोई कॉम्पनसेशन नहीं देना है. So how the defense has been taken by the other party, that is the defendant. So it is the reply of the defendant to the plaintiff dealing with all the material facts which are set out in his plaint. So you can say this is a reply of the plaint given by the defendant party, that is the defense. So it files a written statement to the suit and it discloses her defense also, and the suit enters into a contest. And basically, you know that this is also another aspect that now both the parties have, like for example, when you in your moot court competition, you would have seen that you exchange your memorials. So both the parties are now well versed with the other party, other points, what the other party wants to portray and what the other party has put in allegations, and now they are very clear. So it is it invites the court to adjudicate upon the dispute, but to welcome before the produce before the court, so that the arguments can be based upon that, and what the other party may produce the arguments. तो एक तरीके से आप ये कह सकते हो कि नाउ ये जब दोनों पार्टीज ने अपने अपने पक्ष रख दिए, तो कोर्ट के सामने है कि कोर्ट उसको कैसे एडजुडिकेट करती है और दोनों पक्षों अपनी क्या क्या वो आर्ग्यूमेंट्स पुट अप करने वाले हैं. तो इसके बेसिस पे आगे केस बढ़ता है. All those applicable to plural pleadings, generally plaint are also applicable to the written statement. Next is Order 8, Rule 1 of CPC. This is very important actually in terms of, although I have included it, the defendant shall within 30 days from the date of service of summons on him present a WS office defense. This is basically a time period. इसमें आपको, इसलिए मैंने इसको include किया, इसमें आगे आपको limitation act भी पढ़ना होगा. You have to keep in mind that if there is any plaint or WS, what are the time limitations for filing the case or reply, और जैसे अभी देखा होगा आपने चेक के केसेस में जहाँ पर कुछ ऐसे केसेस आते हैं जहाँ पर निगोशिएबल इंस्ट्रूमेंट एक्ट है, तो वहां पर आपको कितना लिमिटेशन पीरियड है, कितने दिन के अंदर आपको अपनी नोटिस सर्व करनी, कितने दिन पे आपको, सपोज मान लीजिए कोई लैंडलॉर्ड टेनेंट का केस है, तो आपको केस इनिशिएट करने के पहले कितने दिन पहले आप उसको लीगल नोटिस सर्व करते हो, या फिर नेक्स्ट तारीख के पहले आपको क्या करना है. तो देयर आर ऑलवेज अ लिमिटेशन पीरियड, सो यू हैव टू बी वेरी थॉरो विद दैट. कि आपको किस लिमिटेशन में क्या चीजें फाइल करनी। ये तो मैंने एक आपको सिर्फ एग्जांपल दिया। देयर आर अ प्रॉपर टाइम लिमिटेशन in the cases as accordingly the limitation. Now, the object of pleading is always, yes, to give a fair notice to each of the party what the opposite case is, and to be very certain about what the both the parties are going to present upon and what points they are going to argue with, and on which points they differ their opinion and what are their issues. So this makes very clear to the court, and now both the parties are prepared with support of their evidentiary proofs now for the further arguments of the case. So this is how to narrow down the controversy between the parties to a definite issues. Lastly, the sole object of pleading is that the side may be fully active to the question that are about to be argued, and they may have a good opportunity to put up their evidences in appropriate ways. Right? Next is fundamental. Yes, now we are coming ahead to the main issues that are important here. To know as a lawyer, to know as an advocate, that these are important aspects for a law student, which are very, very important. Fundamental rules of pleading. As you know, Order 6 of CPC, the whole chapter is precisely given upon that what are the fundamental rules of pleading. Firstly, that every pleading must state facts and not law. While you are drafting your plaint or WS, you should always keep in mind that you are not going to show the torch to the court, but you will be putting up your facts and in such a mannerism, such an intelligent way that you must state the facts, but not the law to the court. आपको कोर्ट को फैक्ट बताने हैं, आपको कोर्ट को लॉ नहीं बताना है कि आप ये यहाँ पर नेग्लिजेंस हो गया, यहाँ पर ये मर्डर हो गया, या इन्हों पे ये किया, या सिविल ड्राफ्ट की हम बात करते हैं तो सिविल केसेस में आपको कोर्ट को ये नहीं बताना है कि हमारे साथ ट्रेसपास हुआ या हमारा ये पार्ट परफॉर्मेंस ऑफ कॉन्ट्रैक्ट इन्होंने नहीं किया। आपको सिर्फ फैक्ट्स बताने हैं। सपोज इफ देयर इज एनी केस दैट वन पार्टी has put an agreement and they had a contract with the another party. A and B had a contract that upon completion of certain tasks B would pay the amount to the A, but B has not paid, B has failed. So you have to mention in your plate those facts. You are not going to tell the court that he has cheated or he has anyways he has put any kind of allegations. You are not going to put those words like for negligence or cheating or any kind of such allegations on the other party. You have to state the fact, but in a smart way that those facts are in turn creating a compensation on the other party. That means you may get a good compensation from the other party to your client. So you have to put up the facts in that mannerism, but you do not have to show the law to the court because the court is already well versed with the law. The court will give you the proper remedy. Secondly, second important point is that it must state all material facts and material facts only. You have to be focused. It means that as per the case, whatever the important and the material facts are there, you should be focused upon that only. You should not talk in the irrelevant. You should not include other irrelevant facts which are not related with the case. So it is one of the important fundamental principles that only and only material facts which are relevant with the case. Thirdly, it must state only the facts on which parties pleading relies and not the evidence by which they are to be proved. When you're filing a case, you're putting your plaint or WS, you have to put your, while pleading, you're not going to put up the evidence at the first instance. You have to put up all your facts. Later on, later stage, when the court asks you to produce the evidences, when they allow you, you are supposed to put up your evidences. So this is the third important aspect. Fourth is this. It must state facts concisely but with precision and certainty. Yes, this is really important. आपको बहुत ही एक शॉर्ट फॉर्म में, बहुत ही कंसाइज वे में, बहुत ही प्रिसीजन तरीके से, सर्टेनिटी के साथ, सर्टेनिटी मायने क्योंकि अगर डेट ऑफ बर्थ 10 अप्रैल है तो 10 अप्रैल ही है। इफ इट इज 10 अप्रैल 2026 हैज टू बी 10। ऐसा नहीं कहेंगे कि पूर्णिमा का चांद जिस दिन निकला था उस दिन जन्म हुआ था। कई बार ऐसा होता है, तो कई बार हम गलतियां करते हैं, तो हमें ऐसा नहीं करना है। वी हैव टू वेरी वेरी प्रिसाइज, वी हैव टू बी सर्टेन ऑन द डेट्स एंड द अमाउंट्स. Like for example, if there is a compensation of amount 48,000, there has to be a 48,000 only. You do not have to write, it is lump sum around 48, 48. You do not have to use such kind of things. Now, these are some points which a good lawyer should always bear in mind. The following points, like the names and places which you are mentioning in your plaint, आप जो अपनी फैक्ट शीट में मेंशन करते हो, उन सब चीजों के नाम, उन चीजों को बहुत ही एक्यूरेटली उन चीजों को आपको मेंशन करना चाहिए. दूसरा, कुछ चीजें ड्राफ्टिंग के दौरान यू शुड बी वेरी केयरफुल. Like for example, plaintiff or the defendant should not be addressed by their names at some places. You should, like for example, where one has to distinguish between two or more plaintiffs, they can be referred as plaintiff Rama Shankar or defendant Hariharan. So you should, while pleading and drafting, you should be careful on these aspects. Secondly, a lawyer should also put up his facts very boldly and plainly, should use the language of the document, the act itself, and should not invent his own language. आप उस language को इतना interpretation मत करो कि उसका language का meaning, content, intent बदल जाए. आप उसको as it is put up करने की कोशिश करो, उसमें अपने words मत डालो. ये बहुत important है. Next है, every pleading shall be signed by the party and his advocate. Yes, these are some important things that parties should sign these pleadings carefully. Pleading shall be verified by the parties. Verification is important part. And अभी करंट लॉज के अकॉर्डिंगली और जो भी रिसेंट लॉज है, जो कोर्ट फीस वगैरह है, वो आपको थोड़ा अपडेट रखने की जरूरत है. ये टाइम टू टाइम चेंज होता रहता है. फॉर एग्जांपल, आप आरटीआई का केस फाइल करते हो तो आपको देखना होगा कि कितने कितने रुपए का टिकट लगेगा. अगर आप 2 करोड़ की कोई प्रॉपर्टी रजिस्ट्री कराने जा रहे हो तो यू शुड बी वेरी क्लियर कि भाई इस पे कितने की स्टैम्प है, कितने का स्टैम्प ड्यूटी है, इसका कोर्ट फीस कितना है, इसका लिमिटेशन पीरियड कितना है, खसरा खतौनी क्या होता है, और अभी ऑनलाइन भूलेखा में क्या क्या है. तो ये सारी चीजें आपको पता होनी चाहिए. और अभी तो आई थिंक इट इज वेरी गुड दैट अभी बहुत सारी चीजें ऑनलाइन प्लेटफॉर्म पे भी हैं, तो इट इज वेरी इजी टू चेक एंड एक्सेस. इवन लॉट ऑफ थिंग्स आर देयर नाउ, इजी फॉर ऑल. Now coming to the, now we are coming closer to the planes, that the drafting very mannered way, how the mannerism of the plaint is. If you could see in the heading, the plaint can be virtually divided into following, although these are, whether it is a plaint or it is a WS. These are the 3 points which are important. The first is the heading of the, heading means it includes the name of the court and all, and the parties and the addresses and all. Next is the body of the plaint. I'll show you right now how it has to be. And body of the plaint will include the cause of action, the facts of the case, how the right exists and how the right has been violated, how the cause of action has been created, and lastly, all the details in that body of the plaint, all story, all incident very precisely, कैसे क्या क्या हुआ, उन सब चीजों को आप उसमें मेंशन करोगे. एंड लास्ट इज योर इम्पोर्टेंट पार्ट, दैट इज प्रेयर. आप पूरे केस में क्या प्रेयर चाहते हो कोर्ट से, और आप सही कोर्ट में हो, ये सारी चीजें आपको इसमें ध्यान रखनी है. तो मेजरली आपका जो पूरा प्लेंट है वो 3 पार्ट्स में आपका ड्राफ्टिंग डिवाइडेड होता है. फर्स्ट पार्ट इज योर हेडिंग पार्ट, नेक्स्ट इज योर बॉडी ऑफ द प्लेंट, एंड थर्ड इज द प्रेयर. आप अपनी प्रेयर में क्या कोर्ट से चाहते हो. These are some specific rules in relation to plaints as are under I have mentioned. It is specifically like, for example, if it is a case of a recovery of money, the plaintiff must state precise amount claimed, and the plaintiff sues for mercenary profits or if an amount which cannot be estimated despite the exercise of reasonable diligence. So these are the things. Valuation has to be very accurate accordingly. मैट्रिमोनी के केसेस में आप देखोगे डिफरेंट होगा. इंश्योरेंस के केसेस में आप देखोगे वो कैलकुलेशन बेस्ड होता है ना. डिफॉर्मेशन पे आप देखोगे तो अलग अलग केसेस पे आपको क्या क्या जरूरत है वो यहाँ पर आपको ये ध्यान देना होगा. और इस पर इट इज ऑलरेडी वेरी मच क्लियरली गिवन इन सीपीसी एज वेल. जब हम सिविल ड्राफ्टिंग की बात करते हैं कि let's suppose it is order 7 rule 3 where the subject matter of the suit is immovable property, the plaint shall contain a description of the property sufficient to identify it along with the available boundaries or numbers. अभी कोर्ट वहां पर रिसीवर भेजेगा, एक अपॉइंटमेंट किया जाता है, रिसीवर अपॉइंट किया जाता है, जमीन को देखने जाएगा, फिर जमीन का मुआयना करेगा, उस जमीन की वैल्यू कितनी है, सर्वे करने पर क्या आती है, तो तमाम चीजें इस तरीके की. तो ये चीजें यहाँ पर ध्यान रखने की बातें होती है. तो जब आप ड्राफ्टिंग करते हो तो ये चीजें आपको वहां पर एज पर द लॉ ध्यान देना पड़ेगा. ऐसे ही where the plaintiff sues in a representative capacity, if it is a minor case of an unsound mind, और ऐसा कुछ केस है जहाँ पर ऐसा आपको केस प्रेजेंट करना है, तो वहां पर आपको ये ध्यान रखना पड़ेगा कि व्हाट स्टेप्स आर नेसेसरी टू इनेबल इंस्टीट्यूट सच एज सूट. Next is plaintiff must show that defendant claims to be interested in the subject matter of she is liable to be called upon to answer the plaintiff's demand. आपने देखा होगा कई बार जमीन के मामलों में, सपोज लेट से फादर है, उनके 4 बच्चे हैं और एक बच्चे के नाम प्रॉपर्टी कर दी एंसेस्ट्रल, द अदर हैज आल्सो अ राइट टू से. सो इफ द अदर पार्टी हैज पुट एनी एन ऑब्जेक्शन, so that is on stake. तो ऐसी बहुत सारी चीजें, आपको ये सारे नॉलेज अच्छी होनी चाहिए so that you should be thorough while you are drafting and you are pleading before the court. Lastly, the plaint has been instituted after the period of limitation prescribed in the law. The plaint must show the ground upon which an exemption is being claimed. मैंने आपको बताया कि लिमिटेशन पीरियड बहुत इंपॉर्टेंट है. आपको हर सूट में हर एक केस का अलग अलग डिपेंड करता है किस केस में क्या लिमिटेशन पीरियड है, कितने टाइम लिमिट में वो केस है. अब आपने फाइल किया, मान लीजिए 6 साल तक उस केस में पैरवी नहीं की गई, या आपने 6 साल तक सोए पड़े रहे, आपने कुछ फाइल नहीं किया, उसका टाइम पीरियड लैप्स हो गया. अब लिमिटेशन एक्ट कहता है नहीं, तो साल भर के अंदर होना था या 30 डेज के अंदर होना था. अब you have lapsed that period, so you do not have that opportunity to file further. So these things are very to be carefully studied while you are drafting, while you are preparing. So these are all from my aspect. Lastly, I have also some sample of drafts. If you allow me some time, so I can go ahead with that. There is one sample.
Excuse me, ma'am.
Yes, yes.
Ma'am, I would want the host to please turn off the real-time text because the PDF is not visible for us.
Oh,
Yes, exactly, ma'am.
is it not visible to you?
Yes.
I'll share you.
Yes, sir.
Okay, so that was all about. I have also prepared a draft, like for a sample of a plaint. Suppose it is for recovery of money or it's a maintenance suit. If you have time, if you want me to just to give you a brief, I can.
Please, ma'am.
Ma'am, could you please
Yes, ma'am,
summarize
sure.
the 17th slide?
17.
Yes, ma'am.
Okay. It is visible.
Yes, ma'am.
Yes,
Yes,
These
ma'am.
are the specific
Yes, madam.
rules in relation to plaint. Like for example, as I told you, na, when you are drafting, let's suppose it is a recovery of money. You have to file a suit for recovery of money. So you have to state the precise amount which you are claiming. मान लीजिए कोई प्रॉपर्टी 50 लाख की है. अभी आप देख रहे हैं ना, राम जन्मभूमि का केस आया, आपने देखा ना, उसमें सबके दिमाग में क्या क्वेश्चन है, दैट द हाउ मच द चंदा अमाउंट, द डोनेशन मनी इज बीइंग मिसिंग, कितना अमाउंट है. तो जब ये केस अभी आगे बढ़ेगा तो उसमें ये चीज देखी जाएगी कि प्रिसाइजली कि कितने अमाउंट की बात हुई, कितना अमाउंट हुआ, कितना एक्चुअल अमाउंट आया और कितना अमाउंट मिसिंग है. ऐसे ही जब आप सिविल सूट फाइल करते हैं तो उसमें कितना अमाउंट का आप क्लेम कर रहे हो, है ना, तो वो ध्यान रखना है. ऐसे ही इमूवेबल प्रॉपर्टी में तो डिस्क्रिप्शन ऑफ द प्रॉपर्टी, कोर्ट एक मुकर्रर करती है, भाई एक अपॉइंट किया जाता है रिसीवर, वो जाकर के मुआयना करके आता है कि भाई आप देख के आइए प्रॉपर्टी को कि वहाँ कितना. आप अभी कभी एक नक्शा खोल के देखेंगे तो आपको दिखेगा भूलेखा में कि वो कितनी प्रॉपर्टी कहाँ किस एंगल पे किस किस उसका क्या पूरा एस्पेक्ट है. तो ये वो सारी चीजें मैंने यहाँ पे मेंशन की है कि देयर आर सम स्पेसिफिक रूल्स. ऐसे ही आरटीआई के केसेस में, तो आरटीआई के पूरे रूल एंड रेगुलेशन से गाइडलाइन. अभी आप टेम्परेरी इंजंक्शन फाइल करोगे तो उसकी अलग स्पेसिफिक है. अभी आपने देखा होगा एक माइनर के बिहाफ पे किसी ने केस फाइल किया, है ना. तो ये सब केस टू केस बहुत सारी चीजें, आपको स्पेसिफिक रूल्स होते हैं जो केस टू केस अलग होते हैं, वेरी करते हैं, और उनको आपको जब आप ड्राफ्ट कर रहे होते हैं तो उनको आपको ध्यान रखना. यू हैव टू कीप इन माइंड दोस पॉइंट्स वेरी क्लियरली while you are drafting, and there are many laws which are to be studied. Not only that, मतलब एक बच्चों के दिमाग में कई बार होता है कि हमने सिर्फ सीपीसी पढ़ लिया बस अब हम ड्राफ्टिंग कर लेंगे, ऐसा नहीं. एक तरीके से ये समझिए, आपको जब नॉलेज ऑफ लॉ हो गई तब आप किसी एक प्रॉब्लम को लेकर के बैठेंगे, आपके पास कोई केस आएगा, तो अब आप उस एप्लीकेशन ऑफ लॉ को कैसे उस प्रॉब्लम को रिजॉल्व करने में लिए कैसे आप ड्राफ्ट करोगे, क्या अप्लाई करोगे लॉ की, उसको रेमेडी आप दे सको अपने क्लाइंट को। सपोज मैं आपसे कहती हूँ कि मुझे आपसे कोई रेमेडी चाहिए, तो हाउ यू आर गोइंग टू ड्राफ्ट? फर्स्ट ऑफ ऑल यू लिसन मी व्हाट प्रॉब्लम आई एम फेसिंग और व्हाट इज माय इशू, how you're going to put up this issue, how you're going to interpret this before the court, so that you help me to get a proper remedy। अब मैं चाह रही हूँ compensation, आपने ले जाके फाइल कर दिया कुछ और। तो ये सारी चीजें बहुत ही पॉइंटेड चीजें होती हैं, ये बहुत इंपॉर्टेंट होती हैं, ये सब चीजें ड्राफ्ट करते वक्त ध्यान रखनी होंगी। और although this is a general rule, so but even I have tried to include all those as best as in my capacity. I have also one draft of for sample that I can share with you if it is okay with you all.
Certainly, ma'am.
Yes, ma'am. Ma'am, if it is possible for you, can you please slow down? You're speaking too fast.
Oh, actually, due to a short of time, I was trying to. If you could allow me, I can. Okay, because this lecture is not sufficient. Like 1 hour is not sufficient. This is a vast topic. When we talk about drafting and grading, this is a very vibrant and important. एक बच्चों के पर्सपेक्ट से भी, और जब आप इंटर्नशिप पे जाओगे आप बहुत सारी चीजें सीखोगे वहां पर, आपको बहुत कुछ लर्न करने को मिलेगा, और फिर भी आपको लगेगा अभी ये तो सीखना बाकी है। तो मुझे लगता है कि मैंने एक जनरल प्रिंसिपल्स के तौर पे भी ये सारी चीजें इंक्लूड करने की कोशिश की है। और आई सपोज कि इन फ्यूचर यू नीड टू गो थ्रू थॉरली स्पेसिफिक पार्ट्स नाउ। अब अगर आपको कोई स्पेसिफिक पार्ट परफॉर्मेंस का केस सूट फाइल करना है तो उसमें क्या क्या चीजें आपको ध्यान रखनी है, तो इस तरह से भी आप कर सकते हैं।
Ma'am, I would like to tell the students that we will try to engage ma'am in another session by the course of this program only. So please don't worry, we will be bringing with another topic also.
Okay, so
Appreciated.
Like for example, very quickly, if allow me, so I'll just share with you. You can see on the screen.
Yes, ma'am.
Let's suppose I'm just sharing you one slide where you can see that food for recovery under order 37 of CPC. You can at the top here, you can see the heading that it is filed. As I told you, there are three major parts. The first part is heading. So heading includes this first part. That is means in which court it is filed. So let's suppose it is in the court of district judge, district Rohini Court, Delhi. Suit number of this year, and suit under this of CPC. In the matter of, now these are the name. This first of all, this is the name of the court, and next is it is the name of the plaintiff versus name and detail of the defendant. This is the subject matter. That means the suit for recovery of rupees 4,19,200. You can see here. Now, most respectively show the first few paragraphs are stating about this is the, actually now from here it starts the body of the plaint. So in the body of the plaint, the first 3-4 paragraphs are stating about the facts of the case. After the facts of the case, it is trying to, you can see here in the para number 7, how the date and bill generated. You can see here, Punjab National Bank, Shadara, and all details are given there. Whether the check was presented by the plaintiff, how it was dishonored. So all the facts and every minutest details are mentioned here, and how the cause of action has been created in mid of the body. And here in the para number 12, you can see here, as I have highlighted, that the cause of action in favor of the plaintiff, right? So after stating the facts, you have to show how the right exists, and then how the cause of action is created. And lastly, your prayer. You can see here. तो अभी आप कोर्ट से प्रेयर, क्या प्रेयर में अपनी आपने क्या क्या पॉइंट देखिए, सिंपल ये छूट फाइल किया गया जिसमें कि पास अ डिग्री ऑफ रुपीज 4,90,200 with interest of 18% per annum. So these are the 3 points which you have requested in prayer. And lastly, the sign of the advocate, plaintiff, place, date, and verification. and followed by affidavits. तो ये इस तरीके से
You
आपको
share this with us.
ये सब आपको ध्यान रखना है, right?
Can you kindly share this PPT in our WhatsApp group?
Okay, okay, certainly, Susan, I shall share this with you. Now I conclude, and with this, I conclude my part. Further, if there are any questions, I welcome all the questions from my side. Although I found that there are a lot of things more to be covered under when we are talking about drafting and pleading. It's a very interesting topic because ultimately you all will be a good lawyer and advocate, and this is very important for a lawyer to learn the drafting and the pleading skills. That's all from my side. Thank you, everyone. I welcome questions if any from your side.
Thank you so much, ma'am, for such an insightful and enriching session. Your valuable guidance on the fundamentals of civil drafting has provided a strong foundation for all our participants. We are grateful for your time, expertise, and practical insights. Okay, we shall now move to the question and answer session. Participants who have any questions may raise their hand or post their question in the chat box.
मैम who decides the interest? यहाँ पे जैसे 4,19,200 का 18% इंटरेस्ट था पर ईयर, तो ये इंटरेस्ट प्लेंटिफ डिसाइड करता है या फिर कोर्ट डिसाइड करता है?
एक तो देखिए, जब कॉन्ट्रैक्ट का केस होता है तो कॉन्ट्रैक्ट में आपको अपने डॉक्यूमेंटेशन शो करने होते हैं कि इतना आपका कॉन्ट्रैक्ट था आपके आपकी दो पार्टीज के बीच में एज पर द इंटरेस्ट. लाइक सपोज आपने कोई ज्वेलरी खरीदी और उस पर एज पर द रेट ऑन दैट पर्टिकुलर डेट ऐसा ऐसा कॉन्ट्रैक्ट साइन हुआ और आपने वो ज्वेलरी खरीदी, ठीक है, या आपने कोई ऐसा लोन लिया. तो एक तो वो होता है डॉक्यूमेंट में जो आपकी और दूसरी पार्टी के बीच में डिसाइड हुआ है, ठीक है. उसके अलावा जो जनरल एक होता है इंटरेस्ट, उसको इंक्लूड करते हुए वो ध्यान रखते हैं और कितना टाइम पीरियड हो चुका है. मान लीजिए 4 साल बीत चुके हैं, राइट, तो अकॉर्डिंगली द रेट ऑफ इंटरेस्ट विल बी डिसाइडेड. तो इट विल बी डिसाइडेड एज पर केस टू केस एंड इट समटाइम्स इट वेरीज आल्सो फ्रॉम वन केस टू द अनदर डिपेंडिंग अपॉन. अब ज्वेलरी के केस में कुछ अलग हो सकता है. मान लीजिए बैंक का रेट ऑफ इंटरेस्ट है, सपोज बैंक का कोई केस आ गया तो उसमें सपोज बैंक देती है 8.1. कोई पीएफ से रिलेटेड केस है आपने फाइल किया है तो उसमें उनका फिक्स है, तो वहां पर उसके अकॉर्डिंगली डिसाइड होगा. किसी अदर केस में अगर आपके बीच में कोई डील हुई है कि भाई हमें 15% इसका मेरा फायदा है और ये मेरा पर एनम के अकॉर्डिंगली मेरा है और मैं ये रिकवर करूंगा एवरी सेकेंड ईयर, राइट, तो उस अकॉर्डिंगली डिसाइड होगा. तो देयर आर इट वेरीज फ्रॉम वन केस टू द अदर एज पर द फैक्ट्स ऑफ द केस. अभी सपोज ज्वेलरी का है, आजकल आप देख रहे होगे कि ज्वेलरी का बहुत फ्लक्चुएशन रहा, ऑयल का रेट बहुत फ्लक्चुएटेड रहा. तो अगर ऐसा कोई केस आता है इट विल डिपेंड अकॉर्डिंगली जो उसके नॉर्म्स होते हैं, इस पर नॉर्म्स एंड रूल्स, राइट.
Yeah, thank you.
एनी अदर क्वेश्चन?
Good evening, ma'am. Ma'am, I have a question. So, ma'am, this civil drafting, the sample which you showed us, is it based on the specific performance of the contract?
It was basically for recovery of money. There are many other samples. This particular specific was based upon for recovery of money. किसी ने किसी को पैसा दिया था और वो रिकवर उसे करना था, तो काफी साल तक उसने नहीं दिया, एंड बाद में जब ही वो इज एक्सपेक्टिंग टू रिकवर दैट मनी एज पर द इंटरेस्ट he has claimed that I showed you in that my PPT, right? So this case was based upon that suit was filed for recovery of money.
Thank you, ma'am.
Good evening, ma'am. Ma'am, my question is, I am facing the issue of language. Currently, I am doing my first internship in the district court. I have completed my first year. So the major issue for me is the language because in the law school, I am studying everything in English. But in the courtroom practice, most of the documents, petitions, everything is in Hindi. How to tackle that?
हाँ, ये एक आपने बहुत अच्छी चीज पूछी. बेसिकली ये प्रॉब्लम कई बार होती है डिस्ट्रिक्ट कोर्ट्स में और बेसिक सिविल कोर्ट्स में ज्यादातर बेटा हिंदी लैंग्वेज में यूज करते हैं। तो आपको अगर आप प्रैक्टिस भी करनी है या एडवोकेसी में जाना है या आप फ्यूचर में जुडिशरी की भी तैयारी कर रहे हो, आपको इंग्लिश और हिंदी दोनों ही लैंग्वेजेस पे बहुत अच्छे से कमांड करना होगा। हाँ, ये जो प्रॉब्लम आती है, तो यहाँ पर हाउ यू आर गोइंग टू रिजॉल्व इट दैट व्हेन यू आर ड्राफ्टिंग, राइट, सो यू टेक हेल्प फ्रॉम समवन हु इज गुड एट हिंदी। तो आप बेसिक चीजों से स्टार्ट करो, जो पहले सैंपल ड्राफ्ट होते हैं उनको लो, और वहां से आप बेसिक सैंपल से स्टार्ट करते हुए तब आप आगे की ड्राफ्टिंग स्किल्स शुरू कर सकते हो। दूसरी चीज, कुछ लीगल टर्मिनोलॉजीज होती है, लीगल वर्ड्स होते हैं जो एज इट इज ही यूज किए जाते हैं। ठीक है, तो जैसे फॉर एग्जाम्पल तहरीर, एक छोटा सा वर्ड है तहरीर, आप उसे इंग्लिश में FIR कहते हैं, कहीं कहीं पर तहरीर कहते हैं, वकालतनामा आप इंग्लिश में जानते हो। ऐसे जब आप ड्राफ्ट कर रहे होते हो तो आपको लैंग्वेज, वो तो प्रैक्टिस करते करते ही धीरे धीरे आपको आएगी। तो आपको किसी अच्छे एडवोकेट के साथ जिनका हिंदी इंग्लिश दोनों में कमांड हो, उनके साथ आपको धीरे धीरे वो आएगा, एकदम से नहीं आएगा। आपको इंग्लिश की अगर आप ड्राफ्टिंग कर रहे हो तो इंग्लिश का अलग है, और हिंदी में जब आप ड्राफ्टिंग करते हो तो कुछ सैंपल्स होते हैं, वो एज इट इज स्टैंडर्ड फॉर्मेट होते हैं। जब 2 4 5 बार आप उनको यूज करने लगोगे, आप उनको ड्राफ्टिंग करने लगोगे, तो आपको धीरे 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 स्लोली बाय द टाइम वो आप उनको लर्न, एकदम से नहीं आएगा वो। और आपको वो चीज कहीं ना कहीं, मैंने कहा ना, ये प्लीडिंग एंड ड्राफ्टिंग, देयर आर 2 एस्पेक्ट्स। तो वो ड्राफ्टिंग के साथ साथ आपको प्लीडिंग में भी आना जरूरी। मान लीजिए आपने ड्राफ्ट कर दिया, आपने हिंदी में ड्राफ्ट करके कोर्ट के सामने रख दिया, अब आप उसको बोल नहीं पा रहे हो, आप तहरीर नहीं जानते हो किसको कहते हैं, आप शुद्ध हिंदी में, सपोज मैं कह रही हूँ कि ये अंतरराष्ट्रीय स्तर का मामला है, और आपको वो चीज अभी उतना क्लियरली नहीं आ रही, तो वो आपको उतना अच्छा फिर आपका एक जज के सामने इम्पैक्ट नहीं पड़ता। इसलिए उसको आप धीरे धीरे प्रैक्टिस में ही आप उसको ला पाओगे। तो छोटी छोटी ड्राफ्टिंग से शुरू करो, और फिर आप उसको धीरे धीरे आपको उसमें एक्सपर्टीज पाओगे।
Thank you, ma'am. Excuse me, ma'am. As you have mentioned in above point that no other fact can be added randomly. So what if any other facts have been found later? Then how can we add that matter fact?
That are actually based upon amendment of pleadings. So जब आप, with the due permission of the court, you can request the honorable court that there is some another, like in this case, and with your permission I want to add some subsequent pleadings, or you want to amend something in your pleadings. With the due permission of the court, you can add those facts in the case later stage, but not at that very later stage. Once the judgment and interim order has been given, अब उसको लास्ट में आप बता रहे हो कि अरे ये तो फैक्ट छूट ही गया, और वो बहुत इंपॉर्टेंट फैक्ट था, है ना। तो एक स्टेज के बाद नहीं, एक स्टेज तक आपको लिमिटेशन तक अलाउड होता है, लेकिन ड्यू परमिशन ऑफ द कोर्ट आप अमेंडमेंट प्लीडिंग की एप्लीकेशन लगा सकते हो, और उसके बाद में कोर्ट उसको अलाउ कर सकती है।
Okay, ma'am. Thank you.
Thank you everyone for your active participation and thoughtful questions. As we come to the conclusion of today's session, I would now like to invite Manas Mishra sir to deliver the vote of thanks. Over to you, sir.
Hello, very good evening, ma'am. Very good evening, all the participants and members of the VIDHIGYATA. So, respected Mudra ma'am, esteemed members of VIDHIGYATA and dear participants, it's my privilege to propose a vote of thanks at the conclusion of this enriching inaugural session of the Civil Drafting Course. And first and foremost, I express my sincere gratitude to Mudra ma'am for delivering such insightful session on the basic principles of civil drafting. Ma'am, when I was asked to call for a panel, some expert. So since I have taken 2 sessions on this platform on the civil drafting. So I was feeling that something is lacking, something that I am not able to deliver to students what they have right to get. So I thought that why we should not start with the basic principles of civil drafting, and with your enriching experience of 17 to 18 years of teaching this subject, so nobody can deliver on basics of civil drafting other than you. So it was
Thank you,
very
Manas.
your
And
ability
thank you,
to
Vidhyata team. I really appreciate. I'm really thankful and grateful to the whole team and especially you to
yes,
organize such
thank
a
you.
wonderful session. I think this is very important and really
Yeah.
meaningful for the budding lawyers.
And
अगर
ma'am,
हमारे बच्चे हाँ
on a personal note, today is a very special moment for me as I had the privilege of being your student during my graduation when you taught me the law of evidence through Microsoft platform only during the COVID days. So
yes,
years
yes.
have been passed since those online classes, and it has been a nostalgic experience for me to attend you again. Your dedication of teaching and your passion for legal education has continued to inspire me just as they did during my graduation days. So thank you so much, ma'am, for being my inspiring mentor. And further, I would like to extend my heartfelt thanks to entire Vidhigyata team for organizing this excellent initiative, creating a platform that emphasizes practical legal skills in commendable contribution to legal education. Our sincere appreciation also goes to Juris Publica, Laws and Beyond, the media partner for supporting the academic endeavor. And a special thanks to you, all the participants, for your enthusiastic performance, presence, and active engagement. Your curiosity and participation made this inaugural session very wonderful, truly successful. As we have just begun this journey into practical legal drafting, I am confident that the upcoming sessions will be equally enriching and beneficial for everyone. With the immense gratitude to our esteemed speaker, Dr. Mudra Singh Ma'am, the organizers, the partners, and all the participants, I conclude the vote of thanks. Thank you all. Have a wonderful evening, and I look forward to seeing you in the next session. And we will try to have a separate topic with ma'am only. So I cannot assure you as of now, but we will 100% try to engage ma'am for one session more. Thank you so much.
Okay, God bless you,
Thank you.
Manas, and
Thank you so much.
all the team. Please continue with this session.
Thank you, ma'am. Thank you, ma'am.
Thank you, Manis Mishra sir, for your kind words. Before we conclude, I would like to remind all participants that the recording of today's session will be uploaded on the official Vidhigyata YouTube channel within 4 to 5 hours. We request everyone to subscribe the channel and stay connected with VIDHIGYATA through our social media platforms for updates regarding upcoming sessions, opportunities, and events. Once again, thank you to our esteemed speaker, Dr. Mudra Singh Ma'am and Manish Mishra sir, and all the participants for making this session a success. We look forward to meeting you in the next session. Thank you.